reformed academic climate. Bentham's preserved body still sits near the entrance to the dining room at University College. I've seen it in recent years. He seems to be doing fine. Bentham died in 1832, but he lived long enough to have a hand in the appointment in 1829 of one of his own students, John Austin, to the chair of jurisprudence at this new University College. Now, Austin, by that date, had already terminated his own law practice. He had an extremely influential circle of friends, however, including Bentham, James and John Stuart Mill, Thomas Carlyle. It is remarkable that in the few years he occupied the chair of jurisprudence, he would prepare but a single volume for publication, and that volume, in time, would profoundly affect how law itself would come to be understood. The book was essentially his lectures and was published under the title, The Province of Jurisprudence Determined. Even this work might have been left on the shelf of forgotten tomes had it not been for his faithful and resourceful wife, Sarah, who saw to it that a revised edition of the work was published as late as 1873. It would be too much to say that Austin or Austin's book or any single book established the field of analytical jurisprudence. Nonetheless, one searches without success for works before Austin's that so clearly distinguish moral and legal concepts and reserve independent status to each. He states the argument this way in his fifth lecture, quote, "The existence of law is one thing, its merit or demerit is another. Whether it be or be not is one of inquiry. Whether it be or be not conformable to an assumed standard is a different inquiry. A law, which actually exists, is a law, though we happen to dislike it, or though it vary from the text by which we regulate our approbation and disapprobation." A law is a law. In German, Gesetz ist Gesetz, an established principle in German law at the time Austin studied at Bonn. At the root, law is a command, perhaps in the form of a wish, covering a range of actions, and declared by the sovereign. The sovereign may be one person, might be a parliamentary or congressional body, a group of chieftains. What establishes sovereignty is the habitual obedience secured through the power of punishment or the means by which to visit an evil on those who disobey. Note what law is in its essential purity and what it's not. It's not a moral maxim, not a religious belief, not the voice of conscience, not an ordinance of reason, not the mind of God. That a given law may agree with what one takes to be the will of God is, of course, possible. It might even be desirable. That the law does not require what conscience forbids is a distinct benefit to one whose conscience is thus supported. But what makes the law law is neither its agreement with religion and morals, nor its compatibility with individual consciences. What makes law is that it is expressed by those possessing sovereign power. So here, then, is a succinct and early statement of what came to be called legal positivism. Law is what is enacted or authoritatively promulgated and enforced. The study of law is the study of actual enactments or commands. It is a branch of neither moral nor political philosophy, but a subject unto itself, calling for rigorous analysis of such key notions as law, duty, obligation, rights. The focus is on the legal concepts themselves, not on their allegedly moral dependencies or sources. Austin was fully prepared to accept both moral laws and divine laws, understanding each of these to be different from each other, and both of them to be fundamentally different from the positive laws brought into being and enforced by sovereign power. Analytical jurisprudence is the subject of the last of these. Moralists and theologians can claim the rest of the terrain on Austin's account. Now, this is all neat and quite stimulating, but it does tend to leave some fundamental issues in philosophy of law more or less untouched. On neither Austin's account, nor those advanced by his successors in legal positivism, is it clear just what enters into the concept of sovereign. Austin's most famous successor was Oxford's H.L.A. Hart, whose the concept of law appeared in 1961. Now, one objective of that work was to repair certain features of legal positivism that had over the years attracted serious criticism. Austin's concept of sovereign was notoriously fluid, leaving the issue of valid authority virtually intractable. And his command theory of law, which ties the command function to little more than the power of enforcement, seemed to confer the standing of legislator on unwanted types. After all, the gun-toting thief who commands us to hand over our wallet would seem to qualify as a lawgiver. Now, Hart's attempt to eliminate such counterintuitive possibilities took the form of something he called the rule of recognition. You see, what the thief or the highwayman lacks, but Congress possesses, is the recognized status as a source of positive law. Thus says Hart, quote, "To say that a given rule is valid is to recognize it as passing all the tests provided by the rule of recognition," close quote. Well, understood this way, law is a collection of laws, and each of these stands as a social fact. It's a social artifact, one might say, not unlike other useful items that societies create for their own purposes. We make clay pots, we make teaspoons, we make tractors, we make laws. Now, as we recognize the Motor Vehicle Bureau as the place that prints valid driver's licenses, so we recognize Congress as the body that passes valid laws. So if let's say the local pizza parlor were to advertise, quote, "valid driver's licenses given with every order," close quote, we would be suspicious enough perhaps to call the police. Not because the offer is immoral, or even because the pizza shop would require high standards of visual and motor skill. Rather, it's simply the wrong place to be granting licenses to drive. So the rule of recognition corrects one of the basic flaws in command theory. It enables all of us to determine whether or not a law is valid by determining whether it satisfies the rule of recognition. Well, of course, the Nazi Party in Germany was a duly elected party by an overwhelming majority. It appointed judges in the traditional manner that judges got appointed, and it otherwise satisfied whatever goes into the rule of recognition in the matter of how law comes about. Do we want to say that this was sufficient to establish that what was ever thereby enacted would stand as valid law? Now, the natural law critique of this entire line of reasoning has been provided by a number of writers, rather early on, contemporary with H.L.A. Hart, by Lon Fuller, in what remains a classic treatise titled Positivism and Fidelity to Law, a reply to Professor Hart. Attempts to distinguish between law and morality, as if the former could have any sort of real function in the absence of moral precepts, fail at both the practical and conceptual levels of analysis, according to Fuller. The moral and rational powers actually presupposed by the rule of law are also at work in distinguishing between law as something to be faithfully obeyed and law as but a word seeking to conceal arbitrary, immoral, tyrannical modes of control. Fuller is fully prepared to insulate the rule of law from specific substantive moral mandates, but he insists nonetheless that the very concept of law requires a procedural morality that will ensure the law's fairness, ensure its consistency in application, its clarity. In his 1964 book, The Morality of Law, he puts the matter this way, quote, "What I have called the internal morality of law is a procedural version of natural law, concerned not with the substantive aims of legal rules, but with the ways in which a system of rules for governing human conduct must be constructed and administered if it is to be efficacious and at the same time remain what it purports to be," close quote. Natural law theory and legal positivism, however, do not exhaust the options in philosophy of law. An influential writer in this field in recent years has been Ronald Dworkin. His criticism of legal positivism